5 defenses to unlawful arrests. Okay, if you're following along in the PDF, it's page 34, I believe. But anyways, okay. So, starts off, this section will be of benefit not only to those who may initiate a suit for false imprisonment, but also for peace officers, as it further outlines what is the extent of their authority. Suits are usually brought about because there is not a meeting of the minds in regards to the facts or the law of a case. If both parties know the law of arrests and what can and cannot be used as a defense to acts of imprisonment, many lengthy and costly litigations can be avoided. Well, yeah, sure. If they did their jobs correctly, yeah, none of that would be necessary. Over the course of the history of arrests, there have been numerous defenses raised against claims of false imprisonment. Yet the basic defense for this charge is usually limited to showing that the arrest was pursuant to law, that the one arresting had lawful authority to so act. Thus, a valid defense or proper justification for false imprisonment would normally be one asserting the legality of the arrest. I guess that was a court case quote. As Justice Hand stated, the law watches personal liberty with vigilance and jealousy, and whoever imprisons another in this country must do it for lawful cause and in a legal manner. Most of the erroneous defenses have been due to misconstruing the requirements of a suit for malicious prosecution with those required for false imprisonment. The burden of proof. In false imprisonment suits or in allegations of false arrest, it can be no defense that one who was arrested must prove that the arrest was unlawful in order to prevail in the suit. Now, it's interesting. I read something, some information, other information on the internet from this one site, and they said the opposite. They said the plaintiff has the burden of proof. So I don't remember exact. I think Charles Weisman points out that that's not the case. So anyway, back to the treatise. Due to the high regard placed on liberty, all imprisonments of a person are deemed unlawful until the contrary is shown. In Halsbury's Laws of England, in speaking on suits of false imprisonment, it says the plaintiff need not prove that the imprisonment was unlawful or malicious, but establishes a prima facie case if he proves that he was imprisoned by the defendant. The onus then lies on the defendant of proving a justification. Again, that was in Halsbury's Laws of England. The only thing, I don't know why you'd be stating that, but anyway, the only thing the plaintiff needs to plead and to prove is one of two things. Either that the defendant made an arrest or imprisonment, or the defendant affirmatively instigated, encouraged, incited, or caused the arrest or imprisonment. When the plaintiff has shown that he was arrested, imprisoned, or restrained of his liberty by the defendant, the law presumes it to be unlawful. Thus, it has been held that in false imprisonment suits, the defendant, in order to escape liability, must either prove that he did not imprison the plaintiff, or he must justify the imprisonment. Stated another way, the burden is upon the defendant to show that the arrest was by authority of law. That's pretty straightforward. In a case where two police officers arrested a man whom they believed committed a felony, the jury was instructed that the burden of proof by a fair preponderance of the evidence was upon the plaintiff to show that the arrest and imprisonment were not justified. This instruction was held to be wrong on appeal, where the court stated, quote, "It was long ago said by Lord Mansfield, a gaoler, if he has a prisoner in custody, is prima facie guilty of an imprisonment and therefore must justify." It was said by Chief Justice Best, where a man deprives another of his liberty, the injured party is entitled to maintain an action for false imprisonment, and it is for the defendant to justify his proceeding by showing that he had legal authority for doing that which he had done. Where the arrest was done without a warrant, the person arresting would have to justify by showing he acted pursuant to due process of law, by showing that there was a felony or a breach of the peace committed. Court case quote, where an officer arrests a person without a warrant, the burden rests upon the officer to plead and prove justification. Otherwise, the arrest is prima facie unlawful. Close quote. In a case in Iowa, the mayor of a town had instructed the town marshal to arrest a man because it had been reported that he was drunk and had been disturbing the peace. The marshal arrested the man in his home without a warrant. When the man sued the mayor and marshal for false imprisonment, the court instructed the jury that the burden of proof was upon the plaintiff, the man arrested, to prove that he was not found intoxicated when arrested. On appeal, the Supreme Court of Iowa held that the court announced an incorrect rule of evidence on the matter. The Supreme Court, in defining the correct rule, stated, in 2 Bishop on Criminal Procedure, Section 368, it is said, in matters of evidence, if the imprisonment is proved, its unlawfulness will be prima facie presumed, but authority may be shown by the defendant in justification. If the marshal had a valid warrant, this would serve as justification for the arrest and as the defense to the charge of false imprisonment. Being he had none, and he witnessed no breach of the peace, he had no defense against the charge. The rule of burden of proof is the same in a criminal proceeding where any arrest made without a warrant, if challenged by the defendant, is presumptively invalid, and the burden is upon the state to justify it as one not only authorized by statute, but also as one not violative of constitutional provisions. The invalidity of the arrest will render the search invalid and the evidence obtained inadmissible. This was so held in another court case. It just gives another court case to support what he just said. So the next section is good faith and probable cause. The most common defense raised in false imprisonment suits is that the arresting officer acted in good faith or with good intent. This argument of defense is often raised along with the defense that the officer had probable cause. Both of these defenses are often misapplied to the action of false arrest. Such defenses are more applicable to suits involving malicious prosecution or abuse of process rather than to false imprisonment, as stated by the Supreme Court of Iowa. Quote, false imprisonment is the unlawful restraint of an individual's personal liberty or freedom of locomotion. The good faith of the actor is no justification, nor is it the want or lack of probable cause an essential element, as in the cause of malicious prosecution. Close quote. In cases of false imprisonment, the only essential elements of the action are detention and its unlawfulness. Thus, malice and the lack of probable cause need not be shown, or are not necessary to a proper cause of action for false arrest. These are other court case quotes. Even where the unlawful arrest is claimed to have been for the public good, such a defense will not stop damages. Yeah, I remember when I got pulled over, and I was talking to the cop about the law, and he brought up public safety and public good. He says you have to have a license and you have to follow these statutes because there's big trucks out here driving around and we don't want anybody to get hurt. Like he's using the advancement of technology as probable cause or justification for taking whatever position he was taking, which is, as we know, is absolute nonsense. Here's another court case quote. It is well settled law that the lack of reasonable or probable cause and the lack of malice are elements not entering into the action of false imprisonment insofar as actual damages are concerned. The question of probable cause in its usual sense is not involved in the action for false imprisonment. Thus, according to the great weight of authority, the existence of probable cause is not an element of nor a defense to an action for false imprisonment. A case in South Dakota developed where a sheriff had, due to mistaken identity, arrested the wrong person as an embezzler upon a warrant which did not name or describe the person to be arrested. The sheriff alleged good faith and probable cause for arresting the man. The state Supreme Court held that the fact that the sheriff acted in good faith and with probable cause was no defense, may not be taken into account in determining the damages which will compensate the plaintiff. This is all cool stuff. I'm glad he's covering all these angles. In many cases, officers will try to justify an arrest for a misdemeanor based upon a strong belief that the person arrested is guilty. In such a case, the Appellate Court of Illinois held, in an action for trespass and false imprisonment, probable cause and the absence of malice constitute no defense. In this form of action, belief in the guilt of the party arrested, no matter how strong or well-founded in the mind of the officer or person making the arrest, will not justify the deprivation of another of his liberty, and is unimportant whether the circumstances would lead a reasonable or prudent person to believe that the accused was actually guilty. Yeah, what happened to someone's innocent before being proven guilty? Guess that's thrown out the window, as we well know. In some cases, instead of asserting that the officer acted in good faith, defense is raised that malice must be proven on the part of the arresting officer. This defense is, however, groundless in matters of false imprisonment. Court case quote, in an action for false imprisonment, neither actual malice nor want or lack of probable cause is an essential element necessary to a recovery of general damages. Close quote. Whatever the motives of the arresting officer, they do not cause or bring about a change in the legality of an arrest, as was asserted by the Supreme Court of Missouri. Quote, a lawful imprisonment does not become unlawful because of malicious motives, nor does an unlawful detention become lawful because actuated by a laudable purpose or founded in good faith. Close quote. Closely related to the defense of a good faith or lack of malice is that an arrest is justified where there is no force or injury done to the person arrested. But as the United States Court of Appeals stated, this does not justify an arrest. Quote, all that is necessary to establish false imprisonment is that an individual be restrained of his liberty under probable imminence of force without any legal cause or justification therefor. It is not necessary to show actual force, threats, or injury done to the individual's person, character, or reputation. The lack of malice, the presence of good faith, or the presence of probable cause do not affect the existence of the wrong when the detention is unlawful. Close quote. When a deputy game warden had arrested a man without a warrant and incarcerated him in the county jail, the deputy claimed that at the time of the arrest he had probable cause for believing that the plaintiff was then violating the law by hunting without... Does anybody know what the rest of that is? Except for you, Maria? Hunting without... Why would the dude get in trouble with anybody if he was hunting without a...
license?
Yep. It was held that there was a false imprisonment involved. As the Supreme Court of Alabama said, quote, in false imprisonment, the essence of the tort is that the plaintiff is forcibly deprived of his liberty. Does anybody remember what a tort is?
Torturous act.
Yes, it's getting remedy for one's liberties that has been violated. Here, the essence of the tort is that the plaintiff is forcibly deprived of his liberty, and the good intent of the defendant or the fact that he had probable cause for believing that an offense was committed and acted in good faith will not justify or excuse the trespass. Nice. Close quote. In an action against a mayor and a police court judge, that might be a typo. Anyway, in an action against a mayor and a police court judge for alleged false arrest and imprisonment, it was claimed that the defendants acted maliciously with a design to injure the plaintiff. It was held at the Supreme Court of Kansas, hey Dave, your neck of the woods, that based upon the claim of malice, the defendants were not liable for false arrest. The proper remedy would be an action for malicious prosecution. The court also stated, quote, "The motive with which a restraint of liberty is accomplished, be it evil or good, is irrelevant to the question of whether or not an unlawful arrest has been established. The existence of actual malice is of consequence only as it may afford the basis for punitive damages." The court said, as will be seen, malice and willfulness are not essential elements of false imprisonment, and motives of the defendant, whatever they may have been, are not material to the case, close quote. And the Court of Appeals of Maryland had stated, quote, "In false imprisonment suits, the essence of the tort consists in depriving the plaintiff of his liberty without lawful justification. And the good or evil intention of the defendant does not excuse or create the tort. Any deprivation by one person of the liberty of another without his consent constitutes an imprisonment. And if this is done unlawfully, it is false imprisonment without regard to whether it is done with or without probable cause." Close quote. In a case of false imprisonment, the defendant claimed that the petition did not state a cause of action for the reason that it was not alleged that the imprisonment was malicious and without probable cause. The trial court held that these claims were only valid in suits for malicious prosecution, and that there was a marked distinction between malicious prosecution and false imprisonment. The Kentucky Court of Appeals affirmed this position with various cites. Quote, "It is said, no proof of malice or lack of probable cause is necessary to make a case for false imprisonment." Close quote. Where the life, liberty, or property of the citizen are at stake, good intentions are never good enough. It has been stated that the citizen's liberty must not depend upon good faith merely, but upon legal rules governing official action. That was another court case. Here's another court case quote. "It has been held many times that in cases of false imprisonment, the defendant can only avoid liability for false arrest by pleading justification for the arrest. All other arguments must necessarily fail." So what are the three justifications that a policy enforcer or someone else can stand on? Was the plaintiff committing a felony in his presence, the breach of the peace, or is there a lawful warrant that was executed to arrest the plaintiff? That was my little 2 cents. Ignorance of the law. Have you ever gotten this from a policy enforcer or someone else trying to come against you? "Hey, buddy, ignorance of the law is no excuse." Well, now it's going to be thrown back on them. It is a fundamental maxim of law that ignorance of the law is no excuse to violating it. One such maxim is as follows: ignorance of the fact excuses. Ignorance of the law excuses not. Every man must be taken to be cognizant of the law. Otherwise, there is no saying to what extent the excuse of ignorance may not be carried. Where was that quoted from? Let's see here. Maxims of Law from Charles A. Weisman. Actually from Koch, Bouvier's Institutes. I'm sure you guys are familiar with those publications and the importance of maxims. Okay, we'll continue on. It has been said that an unlawful detention or imprisonment does not become lawful because done out of ignorance of the law. Nice. The Georgia Court of Appeals has held that, quote, "It is no defense that a person perpetrating an illegal arrest or imprisonment is ignorant of the illegality of his acts, close quote. Knowingly committing an arrest which is illegal is sufficient to fix liability. Court case quote, false imprisonment is treated as a tort and also as a crime. If the conduct is unlawful, neither good faith nor provocation nor ignorance of the law is a defense to the person committing the wrong, close quote. After speaking on the constitutional rights of citizens, the Supreme Court of Minnesota further adds, as is the case of illegal arrests, the officer is bound to know these fundamental rights and privileges and must keep within the law at his peril, close quote. Ignorance cannot be an excuse for violating the rights of citizens or any constitutional mandates such as due process, especially by those who have taken an oath to uphold law. They become a hypocrite upon the assertion of such an excuse. Question for the listeners. So if a policy enforcer or somebody unlawfully as a false arrest or false imprisonment, is that a felony? Are they committing felonies at that point?
I think so, Peter. 18 U.S.C. 241 or 242, any person under color of law deprives you of your due process or rights is guilty of a felony from 1 to 99 years, plus a fine.
I think that's important to know because, especially if this happens, our fellow man that is committing fraud should be warned that he's committing fraud and he's committing a felony. Put on notice. Where was I? Okay, the next section. Guilt of party arrested. An unlawful arrest cannot be justified because the arrested party was actually guilty of the charge for which he was arrested. The person charged with an offense can only be deprived of his liberty by due process of law, and this constitutional safeguard applies to the guilty as well as the innocent. Thus, the guilt of the one arrested has no bearing on the legality of an arrest. As stated in Annotation 25 ALR 1519, I don't know what that is, but anyway, it says, no one can recover damages for a legal arrest and conviction. Therefore, in cases of malicious prosecution, it becomes necessary to await the final determination of the action. But the same principle does not apply to an action for false imprisonment, as the form of action is based upon an illegal arrest, and no matter ex post facto can legalize an act which was illegal at the time it was done, close quote. Thus, nothing that happens ex post facto, which is after the fact of the arrest, can change the legal nature of the original arrest. A prosecution and verdict of guilty does not make an unlawful arrest lawful. In a case of false imprisonment, where it was being asserted that the plaintiff was guilty, the Supreme Court of Oklahoma said, the guilt of the plaintiff is not material. In the Michigan Law Review, it was stated that an arrest is unlawful, even though the arrestee be guilty of a felony, if the officer had not reasonable ground to believe him guilty, thus neither the guilt nor innocence of the person arrested has anything to do with the legality of the arrest, close quote. It thus has been declared that in an action for false imprisonment, the termination of a prior proceeding in favor of the one deprived of his liberty is not material to his suit. Since termination of the proceedings is not material, the fact that one deprived of his liberty was actually found guilty is immaterial to the false imprisonment suit. But in a suit for malicious prosecution, there must be a termination in the proceedings in favor of the party deprived of his liberty to prevail. If he is found guilty, he cannot sue for malicious prosecution. A false imprisonment case in New Jersey occurred where a woman was committed to an insane asylum by a business partner and was released a few days later by her husband. The woman sued the partner for false imprisonment. but it was argued that the woman failed to plead or prove that the proceedings leading to her arrest and imprisonment in the asylum had terminated. The appeals court said that the argument raised did not apply to this case as it was an action for false imprisonment and not malicious prosecution. The court held, quote, "The weight of authority is against the proposition that in a suit for false imprisonment, the prosecution should terminate before a suit for damages can be instituted." I don't understand what I just read there. The weight of authority is against the proposition that in a suit for false imprisonment, the prosecution should terminate before a suit for damages can be instituted.
Means they should dismiss the case and hope they don't sue.
Oh, if it was for malicious prosecution instead of the false imprisonment.
No, even for false imprisonment. You know.
Okay.
That's the way I hear it. You know, they're going to dismiss the case. You know, we're not going to pursue it, and hopefully you'll be a good person and let us off, and not sue us.
Yeah. Okay. In a suit for false imprisonment, a record of conviction for the same offense for which the arrest was made is inadmissible. An action for false imprisonment is to be based upon the legality of the arrest, not upon the filing of a complaint, or the proof of an alleged crime, or the results of a trial. As the California Supreme Court said, the finding of guilt in the subsequent criminal proceeding cannot legalize an arrest unlawful when made. Even where a party has pleaded guilty, the one making the arrest can still be liable for an illegal arrest. Thus, it has been held that consent to an unlawful arrest will not excuse an officer or a person from their acts, as held by a Federal Circuit Court of Appeals. Quote, "We are of opinion that the law does not permit the citizen to consent to unlawful restraint nor permit such a claim to be made upon the part of the defendants. No man has a right to take away another's liberty, even though with consent, except by process of law. And the reason is that liberty is an unalienable prerogative of which no man can divest himself, and of which any divestiture is null." Immunity. This is what the corporate employees love. The argument of official immunity would seem to be an obvious and logical argument for an officer in defense for a charge of false imprisonment. Government is generally immune from being sued, and peace officers are regarded as members of government. Thus, it is often claimed they are immune from suit. But the immunity doctrine does not extend to anyone in government who causes a wrong. Court case, quote, "But immunity from a suit is a high attribute of sovereignty, a prerogative of the state itself, which cannot be availed of by public agents when sued for their own torts." Close quote. Under the doctrine of official immunity, there have been distinctions made between acts that are discretionary duties, which an officer in performance of is immune, and acts which are ministerial duties, for which officers remain liable. An officer's official duty is described as ministerial when it is absolute, certain, and imperative, involving merely execution of a specific duty arising from fixed and designated facts. There's a court case quote. An arrest by an officer is a ministerial, not a discretionary act. That ends the section for, what was it again? I forgot already. Defenses to unlawful arrest. This next section starts...
Peter?
Yeah.
Now, this is Dave, if I might insert something.
Yeah.
The Clearfield Doctrine blends right in with the section you just went under, because it says when the government enters into commerce, they lose their sovereign immunity. They become like anybody else.
Yeah.
So that peace officer out there, whatever you want to call him, policy officer, when he enters commerce, and most of the arrests we have are involving commerce, which is traffic violations, they don't have any more rights than you or I.
Yeah.
So,
yep,
that's my 2 cents worth.
Yeah, it's a good point to make. It's good to be aware of that.
In a nutshell, it says when the government, and that includes all government employees, enters into commerce, they lose their sovereignty because they're in commerce, and the rules of commerce apply to them the same as everyone else. They have no sovereign immunity. It's kind of interesting because if we are sovereign people, we don't involve in commerce, we are in trade, but they try to get us into commerce to further prosecute us with their fake laws. But, I think that by exercising or understanding the Clearfield Doctrine along with Weiss's stuff, you have a very, very strong armament against all their actions against you.
Yep.
And that has to do with when a government they incorporate, right? I mean, is that the telltale sign that they're entering into commerce?
Well, basically everything they do is commerce. Because the government, the courts are banks. What are banks involved with? Commerce.
Yeah.
And the courts aren't even courts, but that's another story. But, if you look up the word traffic in Black's Law Dictionary, it has one word for a synonym: commerce. So when he stops you and issues you a traffic citation, he's involved in commerce. He's asking you to engage in a commercial contract, which you can refuse or fight or whatever.
Yeah, and I've been thinking about the unlawful imprisonment in regards to lockdown orders. And so if you've got the state of Alaska governor giving an order that people have to stay in their houses for the next month or whatever, is this, the state of Alaska is an incorporated entity. Is that all the proof you need that they're engaged in commerce? I mean,
I would think so, yeah, because they're not even a government; they're a corporation.
Well, they're depriving you of your liberty, which is false arrest, basically. When they confine you to your house, isn't that false arrest? They had put you under false arrest or house arrest. So actually, all these governors and mayors and everything else are eligible for a tort claim.
Yeah, and people need to start suing them probably. So, but yeah, the way I've always looked at it is when they left the land jurisdiction and incorporated, all the governments, the local governments, the state governments. By 1965, they were incorporated into the larger corporation, but they went from common law to civil law, and to me that's how I think of it, as evidence that they're in commerce. But I just wonder, Dave, if you see it the same way. Just the fact that they're under civil law, doesn't that mean commerce?
Well, I don't see how they can get to you if you clarify the status of your being, and that there are lots of ways you can do that. There's no one special way. You just undo the contracts that they think that you have, all these implied contracts, and say, who else can tell you who you are?
Yeah.
There's a very, very important treaty that everyone should probably be aware of, and that's the 1948 Treaty of Declaration of Human Rights from the United Nations. There's 36 things there. Not all of them are something that I would like, because part of them are pretty socialistic, but there's some nice things there. You have the right to travel. You have the right to leave your country and return to your country. You have a right to determine your nationality. You're innocent until proven guilty. A lot of nice little things. And that's a treaty. And when these public officials violate that treaty, I think that classifies as treason. They're warring against the United States.
Yeah, and I wouldn't claim any rights under the Declaration on Human Rights myself, but I know a lot of people like to use the UN treaty.
Again, that treaty is a bar against them coming against us.
Mm-hmm.
That's the way you're making a mistake a lot of people I talk to make. You think that if you accept something from them that you're falling under their jurisdiction. No, I'm not. I'm saying you made that law. That law is for you, and you're breaking it, trying to enforce it against me.
Yeah. It depends on how you claim it. Because if you're claiming it for your that's where you get your rights, I do believe you fall under their jurisdiction. But that's just an argument. That it's not important. I mean, what you're saying is,
if I'm free to travel and innocent until proven guilty, why is that a bad thing for me?
Well, because you're accepting a benefit. It's a privilege. It's not a right. When it's under the Declaration, we don't need to argue about this. That's just the way I see it. It may not be the way you see it.
Well, go ahead, Maria.
I just wanted to kind of go back into today's study here. There was some things that happened during Chris's arrest that I think are really instructive for us. And I'm trying to remember where we started out. Have we covered in this, we've gotten to the point where they talk about the warrants have to be presented?
That's the next section, and I was going to leave that for next week.
Okay. Warrants, okay, so that was a big part of the falsity of his arrest. Yeah. The other thing was there were two other big glaring mistakes. Let's see. There was no warrant present. Oh, have we gotten to the part where they have to be taken directly to a magistrate?
No, we haven't gotten to that yet. This section on the use of warrants is a bigger section. It's probably going to take us maybe a few weeks to get through it. Obviously, you can read it on your own, and I know you've read it before.
I need to keep reading it over and over because it's a little confusing with the difference between. It's getting more clear the difference between a malicious prosecution and a false arrest, and it sounds like you just have to be proven, you have to be vindicated in order to go for malicious prosecution.
Yeah, as of right now, it seems like Weisman is trying to advise it against that and just focus on false arrest and imprisonment. Because if it's malicious, as far as I am comprehending here, malicious prosecution, the burden of proof is on the plaintiff, where the false imprisonment is not. It's on the defendant, and that seems like that's a huge thing.
Yeah, and then there was just one other little thing that I think is important that you were a witness to it the day when there was a over the teleconference arraignment of Chris, and I went in under common cause or a beneficial interest.
Yeah.
And I mischaracterized it because I thought it was a beneficial public interest, but those are two different things. It's either a beneficial interest or a public interest. In this case, it's both. The way what they're doing to him is a beneficial interest to me, because if they can do it to him, they'll do it to me because of my beliefs. They'll also do it to any member of the public, but what's interesting about what happened was when I made that claim, I wanted to make sure I got it on the record. Do you remember what the magistrate did?
No, but I do have the recording. I don't remember what he did. Let me think. I don't remember.
Well, in the treatise, when the accusation comes and the cross-claim comes, or the claim comes from the person that was placed under an arrest and false imprisonment, they accuse the state, and the state has to prove that it was lawful. It's going to be presumed to be an unlawful arrest, and when you make that accusation, the state's got to prove it was lawful, not the magistrate. It's not his job to prove it was lawful or to say anything about the fact that it was, whether it was, lawful or unlawful, or to dismiss the complaint. It's up to the state to show, and they have to show it. And it didn't have to be that day, but they have to show it, that it was, they have to prove it was lawful. But he immediately piped up and said, well, we had a hearing and got a warrant. I don't know exactly what he said.
Yeah.
There was a hearing and there was a warrant, ahead of time, so it was lawful. So he took on the role of what the state's supposed to do, and that kind of showed he wasn't fair or impartial. And he also he mounted a defense on behalf of the state, and it was really bad. It was a poor defense because the arrest didn't happen until 14 days after that hearing. So how does he know that the arrest was executed properly? I don't believe he does.
Yeah.
Supposedly.
Well, it's a fake warrant. I would suggest you look up on the internet 5 U.S.C. 706, I believe it is.
Okay. About warrants? Okay. Yeah. Well,
no,
and
it has to do about the reviewing party. They will dismiss the whole thing if any of those 5 areas are violated. And the first one says, if the process was arbitrary, capricious, or without the due process of law, it must be vacated.
Okay. All right. So 5
and
U.S.
That's their law, and they're supposed to operate under it.
Yeah.
So when they don't, then now you got their oath of office. Now you got reason to get them out of their job. You find out who handles their bonds, you make a complaint, then they're gone. The bonding company will work with you because they don't want people out there that are bonded that are doing bad things.
Okay, but he has demanded bonds and never gotten a single thing. Have you ever been successful?
They aren't going to tell you. They aren't going to tell you how you can get to me and take money out of my pocket. They're going to make you find them.
So how do you
go either to the state or the county? Go to the state or the county and ask for their budget and look and see where it says insurance.
Okay.
Then call the companies and say, hey, do you handle the bond for this state or county or city or borough or whatever? And then you say, does so-and-so have a bond with your company?
Okay.
And if he doesn't have a bond, then you can write to the Attorney General and have him come and arrest him for impersonating a public official.
And does the Attorney
General... the Great Bar Motel.
Yeah. Does the Attorney General in your state take complaints against the bonds, or do they give you any information on bond?
I'm not making a complaint against the bond. I'm making a claim against a guy that says he's the sheriff or the judge or something, and he isn't bonded. That's against the law.
But it's an insurance claim, isn't it?
Yeah, that's all it is an insurance claim.
Yeah.
But if they violate their bond, the insurance company pulls their bond. If they're not bondable, they can't work for a government agency of any sort ever.
Yeah.
They lose their pension and everything else if they're a judge or even a police officer. We have a lot of power if we just learn how to use it. Want to get caught up in little things. Put them on the defensive. We want to play. We want to play defense all the time. Let's go on the offense. Rule 13 of civil procedures, when you're presented with a claim, you make a counterclaim or you waive that right.
That's what
Rule 17.
That's what's the study.
There must be a ratification of commencement. And most people don't know what that means. They've changed the wording around, but basically it means that both sides have to agree to the rules that you're going to follow. And there must be a real party of interest.
What was that called again, Dave?
Rule 17, Civil Rules Procedure, ratification of commencement.
Yeah, it's all learning process. Well, that's what this study's for, hopefully.
Rule 1 of the civil procedures is kind of interesting. There's only one process, and it's civil. What is it? CFR 7210, Code of Federal Regulations. All crimes are commercial. Everything that's out there, murder, rape, robbery, extortion, they're all civil crimes. The only thing they care about is the money.
They're all, I was just reading the canon law. It's in David Straight's affidavit, and it talks about, let's see, it's actually where I was in that.
Every case has to be bonded, and guess who bonds the case against you? The prosecuting attorney uses your trust to create the bond to put you away, and then they collect more money after they put you away.
It's a canon law 3224, commercialization of various securities, bonds, and bailments. So, that's how the money goes through, but
well, when you sign court papers, you authorize them to access your Treasury Direct account, which is considerable. Mm-hmm. You're born and get a Social Security card, it's worth somewhere $2 million to start out with, maybe more. And then the interest they earn on it and the investments they make with it are added to that. By the time you get up to be 65, it's worth over $100 million. That's the reason they want to kill off old people, because that money goes back into their pocket.
Is that, you're talking about the Treasury Direct account?
Right.
Is that
associated with a Sesquique Trust, which is what they operate your Treasury Direct account out of a Sesquique Trust.
Okay, so the Sesquique trusts are, I'm reading here, when a child is born in a state, 3 Sesquique trusts are created upon certain presumptions, specifically designed to deny the child forever any rights of real property, any rights as a free person, and any rights to be known as a man or woman rather than a creature or animal, by claiming and possessing their soul or spirit. That's Canon 2048, and that's just David. I think that's just David's strict description.
What they do is they kill you at birth. They don't kill you; they're twins. One is alive, and the other one's the placenta. They create the dead person out of the placenta, who's lost at sea, and that's how they set up that trust. And they make the living person actually you're the beneficiary, but they assign you the position of trustee. So you're responsible for everything that placenta does throughout life. But the way you get control of that is you become a secured party creditor.
Yep. Mhm. Yeah.
Because they never do that. All they got is their presumption and assumption. Well, this is there. Well, where's any documentation of it? I got a UCC file that says he owes me. And you're trying to take money from him. First, you have to pay me what he owes me.
Now, what was that? What are you saying exactly there? I didn't quite catch it.
Said before you do anything with him, you have to pay me what he owes me, because I have prior claim on him.
Now, who's he in this example?
The straw man.
Oh,
the placenta that they put into the Sesquique Trust. And the fourth paragraph on the Sesquique Trust says, if the person presumed to be dead or lost at sea should reappear, the government must return his estate plus the interest that's earned on it over the years of his absence.
Yeah, let me read that one. Canon 2057. Any administrator or executor that refuses to immediately dissolve a Sesta KV trust upon a person establishing their status and competency is guilty of fraud and fundamental breach of their fiduciary duties requiring their immediate removal and punishment.
Ta-da!
Yep. But you have to reestablish competent living status in their system.
Well,
I'm sorry, go ahead, Peter.
You know how you do that?
Show up? I don't know.
Nope.
There's all kinds of stuff.
The most powerful guy in the counties, at least in the lower 48, is the coroner. The sheriff runs everything, but the coroner is the one that deals with dead people. And you go to the coroner and say, this is my birth certificate. They've got this person in all capital letters that's been impersonating me for years and years, and they say that I'm dead in society, so I'd like you to have you examine me and certify that I'm alive and well and in normal health.
Dave,
and
two
a court
questions.
Cannot deny a coroner's stuff into the court. I know because in my case, we were putting a lot of stuff in the court, and the court wouldn't accept it. And so I did some research, and I said, hey, let's send it through the coroner. So we sent it through the coroner's office, and immediately the prosecuting attorney jumped up and down crying like a little third grader. Judge, make these guys quit putting all this paperwork into the court. Now, a lot of counties don't have coroners anymore. Ours doesn't. They hired it out to a laboratory in Kansas City.
Well, I thought you could just show up and make a declaration that you're rebut the presumption that you're dead.
In my allocution, I took my diabetic finger pricker and pricked my finger and said, I'm human. I'm a man, living man on the land. I bleed. This court has no jurisdiction. But again, they didn't pay attention. So you need the coroner's certification. Maybe 2 medical doctors would work.
Well, if you go by this law, it says you show up and you show that you're competent. And there's a lot of people out there talking about what it takes to prove that you're operating in the private instead of in the public. So.
Well, does it make any difference whether I can operate anywhere? If you read David Straight's stuff and what he talks about, Genesis 1, 26, 27, 28, God created man in his image. He gave him dominion over the beasts of the field, the birds of the sky, and the fishes of the sea. And if you look at that, it spells law. Beast of the field is L. The birds of the sky are air or ecclesiastical. And water is, escapes me right now, is
W.
Land, air, and water.
Admiralty law. So man doesn't make any difference what you operate in. He's in charge of it.
Yep.
God did not give us one man any power over any other man. I'm trying to build my group down here, and I've got a T-shirt that I give out to all of them. On the front side it says, my rights end where your nose begins, and on the back side it says, your rights end where my nose begins.
Yep.
That's what it's all about right there. If everybody followed that rule, we wouldn't have to need 80 million laws, and I don't know how many lawyers we got, but we could send them all on a Titanic voyage to the Antarctic or something.
Hey, Dave, what was that from the Code of Federal Regulations? What was that section where it says every crime is commercial?
I think it's 27 CFR 7210. I'd have to look it up. I used it a lot when we were in prison writing paperwork. But That's been 8 years ago now.
Well, I've been.
If you use that one and that 5 USC 706.
What was that?
Those 5 USC 706. That's the one that talks about the reviewing of any action by a federal agency, and it says that if any of the following happens, the case must be dismissed. And this starts out if it's arbitrary, capricious, or without the normal, I don't know exactly how they worded it, without the normal operation of law. Is there anything that they do that isn't arbitrary and capricious?
Yeah.
And outside the normal due process?
Hey, I want to rewind a little bit. Couple of things that, Maria, you said earlier regarding how the state has the burden of proof. Wouldn't it be better, more specifically, is the man acting as a government Inc. employee having the burden of proof?
Yep.
It's because obviously when usually these...
Well, he's making the claim then, Peter. You know, did you ever watch that program on television, Judge Mathis out of Detroit?
No.
It's a thing. Well, when he got up there, they'd introduced the plaintiff and the defendant. I need to look at the plaintiff, and he said, "Prove your case." So the claimant makes a claim, prove their claim. Instead, we sit here and want to defend what we did. Hey, prove your claim.
No, when
Prove
we're talking about false arrest and false imprisonment, the burden of proof's on the defendant. And the defendant's not really the state; it has to be the man. I think we should.
When you're making your claim, the defendant turns out to be the arresting officer.
Right, but not filing the claim in his capacity as an officer, but as a man.
Well, we're filing the claim against him.
Right, that's what I'm saying. Not the state in general, because when they come against us, it's usually the state of or the Commonwealth of versus,
That's fine. The law says you're supposed to be able to face your accuser and cross-examine him. We'll bring the state in. I'd like to see him.
Yeah. Another thing too, I wanted to mention. Maria said like these things don't really like the UN Declaration of Human Rights. We have to remember that Jesus often said to the Pharisees, doesn't your law say this? And then he would say what God's law says. So even though there are things that you could still say, well, this is what your law says right here, like what Dave was saying. It's for our benefit. So it's actually we're using it for our benefit against them to pretty much disarm them and neutralize them. So I just wanted to mention that.
The only thing I would say about the man-to-man thing is, and I always worry. I always have to think about this a bunch of different times because on one hand, you're in a proceeding where everybody's characterized as their persons. And to me, it seems like you might want to put, Officer John Doe, man, and officer. But it seems advantageous at times to just treat them like the persons they are. Because the law is all written, the code's all written in terms of who's who, and they're not under that court's not competent to deal in matters of common law. The court deals in the civil rules. That's the only thing they're competent to work in. So I don't know. I don't know that it's a benefit to us to try to pull it out man to man, because then the court's not competent to hear it, and they say that see us any more than they can see gold or silver. They can't see us, and they can't deal with us because we're their creator. So if you're going to pursue the state and say, make a claim that you were placed under arrest and false imprisonment, maybe you can say, I, the man, the soul-bearing entity, was dealt this way by one of your officers who's also a man. You may be able to get by with that, but I think at some point you need joinder between the man and the officer in order just for them to be able to be capable and competent of dealing with it at all.
Yeah.
So I keep going. I go back and forth on that a lot. But on this one with Chris, I think I'm just going to keep it simple and take standing under a common cause, under public interest, and put the paperwork in that I've already written, and then bring the law. And to me, the biggest problem we have is nobody ever pushes back and brings the law on these things, and so they just have to assume we're all ignorant of the law, and they can continue to run over us. We should be following the law, and that we should be bringing our land patents forward. And I can definitely, I can believe in that for certain. I can take that to the bank. So that's what I'm doing.